Good evening. The old Saybrook Planning Commission. You have various powers that are given to you by statute, and then you have your own regulations too. So we can do next one. Do I have power over this at all? No, good. All right, keep going. Legal authority and responsibilities. All right. Oh, we went too fast. Oh, you're going the wrong way. Somebody needs to go back. Oh, look at that. All right. Bingo. Well, there we go. So one of your powers and duties as a planning commission is to adopt and amend plans of conservation and development. I think, once every 10 years, you have to adopt a whole plan of conservation development. And if you don't tell the state that you've done that, and you might consider the fact that you could possibly lose funding. I think, and Chris, correct me if I'm wrong, the last time they did this was 2014, that they adopted a full.
Correct. So what happened was the Planning Commission historically, for the past 20 years, has been adopting a section every year or two and calling it a working document. But for some reason, the state has our last comprehensive update as 2014. Okay. So right now we're working on updating the residential section will be our next, and maybe trying to update to have a whole comprehensive plan in one document, and kind of call it the 2021 10-year plan. It's a lot of work, but we'll try to do as much as we can to get us up to date.
That's great. That's something that you have to do. It's one of your responsibilities, powers and duties, and you have to stay on top of it. Every once in a while, the Planning Commission forgets they haven't adopted one in many years, and then the state comes around and bothers you. So it's something you want to do, and it's great if you can get it, a comprehensive one done this year. I know you've been doing amendments over time, and you might as well just slam them all together and make it a comprehensive one. Second, one of the other powers and duties that you have is a review of proposed municipal improvements under Connecticut General Statute 8-24. I mean, people always call this 8-24 approval. It's like a word of art. It's something that you'll see. And now you can hit the next slide. All right. No municipal agencies shall locate, abandon, widen, narrow, or extend any street, bridge, parkway, anything to do, almost anything to do with public property is something that has to come before you for 8-24 approval. The only thing that doesn't is certain repairs to roads, fixing things, that doesn't have to come before you as a general rule. But if somebody's going to sell a park or a school or anything, some big items, you have the ability and responsibility to review it to make sure it's something that the town should be doing. All right. So you may get a submission for an 8-24 approval. You have 35 days after the submission date. If you don't act, it's going to be deemed approved. So you can always approve it within those 35 days if you want. If you deny the proposal, you have to say why to the legislative body. A denied proposal may not be adopted until 2/3 vote of the town council or majority of those at a town meeting. So that every once in a while, you'll see a little tug of war, and the Planning Commission will say, oh, wait, don't do that. We don't think that corresponds with a plan of conservation development. We don't think it helps the town. And that creates a little bit of a domino. It doesn't usually happen very much. Usually most projects are things people in town want. Okay, number 4, establish, change, or repeal subdivision regulations. So does anybody remember the last time the old Saybrook Planning Commission amended its subdivision regulations?
It's been quite a while, I know that. You haven't had many subdivisions lately.
It comes up. Yeah, you don't get too many, but I think that's on a slide. You're going to get some dates that'll tell you when it was first adopted in Old Saybrook and the last amendment. The other duty that you have is to approve subdivision applications. If somebody comes before you and wants to subdivide property pursuant to your regulations, then you're going to have to consider it. And so a subdivision is basically when you take a parcel and you divide it, not the first time, but the next time, that's a subdivision. Now, I'm going to presume that most of the lots in Old Saybrook now have kind of been subdivided to their furthest extent. I don't know of how many large parcels you have to really subdivide, but that is one of your responsibilities. And you can hold a public hearing for a subdivision. It's not required. If it's a re-subdivision, then you have to hold a public hearing. (8-3A). So you have to consider, the Planning Commission has to consider referrals on zoning text and zoning boundary changes. So the Zoning Commission should send you something like, here's some proposed text. You would review it to make sure it's in the ballpark of the plan of conservation and development, that it makes sense. And if you approve it and send a report that says, yes, this referral is positive, things go on their natural course and the Zoning Commission has to consider it. If it's disapproved, then the Zoning Commission must approve that reg change or that boundary change by a 2/3 vote. And once again, if you don't respond in 35 days, it'll be deemed approved. Oh, here we go. So it looks like you first adopted subdivision regulations July 8th, 1948. So that's kind of early for subdivision in Connecticut. Not the earliest, I've seen them a little early. But what that means is that's kind of a moment frozen in time. So if you're going to claim that you have a non-conforming lot, you have to have some parcel that wasn't split after that date, either informally or formally. Now, the last time you modified your subdivision regs looks like it was 2012. So it's been a while, but that's okay. There has not been a lot of subdivision activity in many towns. So they've kind of stayed where they are. Okay, so this is definition of re-subdivision. And re-subdivision means that you're changing a subdivision map that's already been recorded. So right now, in order for a subdivision map to be valid, there has to be an approval from you, the Planning Commission, and that map has to be signed by the chairman or secretary and recorded on the land records. If somebody wants to change that map, change the street layout, affect any areas reserved for public use, change lots, it's usually you're adding lots, then you have to have what's called a re-subdivision application. People come in, there has to be a public hearing for that whenever there's a re-subdivision. The most common re-subdivision you see is someone says, well, we got 5 lots, we think we can fit 10 or something to that effect. It's an application usually looking for more lots.
Mr. Willis?
Yes.
Do you want to take questions while you're talking, or do you prefer that we wait until the end?
As long as we're controlled about this, let's do it while I have topics up and you want to ask so you don't forget.
Yeah, the subdivision, I just want to make sure I understand. In other words, if in 1948 in August, there was a 100-acre parcel and it was divided in 2, and now one of those parcels wants to sell off some lots from it, then that would be a subdivision,
Yes.
re-subdivision?
That would be a subdivision.
Oh, okay. And then if that lot is able to break itself into smaller pieces, that's another subdivision.
Well,
a re-subdivision.
Yeah, let's say you have one lot, one of your two lots, okay? And one of them you want to make 3 lots. So you go in front of the planning commission and you get that subdivision approved. The chairman signs the Mylar, it's recorded on the land records. So then if they want to go and take those 3 lots and make them into 6, that's where you're going to have your re-subdivision. And that's where you have to have a public hearing.
I have a question as well.
Sure, Megan.
I was wondering, so I believe on your first slide you mentioned subdivision applied to dividing lots or parts. Does that apply also to condos or just land division?
Land division.
Okay.
Doesn't apply to condos.
Okay.
Okay, thank you.
All right, next slide. Well, basically what you have in your subdivision regulations is based upon statutory authority. So you might talk about drainage or water or sewage, and you may also talk about how you want things designed for road patterns and things of that nature. These are all kind of statutory requirements, and I'm sure they're all in your regulations. So whenever you get a subdivision application, you know you have to look at your subdivision regulations. And the purpose of that is if the regulations, if the application meets the regulations, then, you know, more likely than not, you're going to have to approve it. If somebody's trying to do something that doesn't fit, doesn't meet your regulations, then you shouldn't approve it. There's other things. You go to the next slide. These are all requirements. Proposed streets are harmonious with existing ones or those proposed in the plan of conservation development. You probably don't have a lot of new streets planned unless I'm missing something. You can't deny a subdivision or site plan, which you don't consider, but based on off-site traffic. If you want to change the pattern inside a subdivision or locations of where the roads come out, you can do that. You don't see as many subdivisions now with new roads because of the cost of construction. One of the items you have control over is erosion and sediment control. And that will come up in a subdivision application. And there's also certain restrictions regarding manufactured homes. Most of the time, you don't have to worry about that. It doesn't come up too often. Street grading and providing bonds or financial guarantees for a municipality to finish public work. So you can't have bonds in general to complete private work. But if it's a road or what's something that's going to be a town drainage, then you could seek a bond if it hasn't been completed. You can also provide for efficient patterns of development regarding energy efficiency. That's something that you don't see as much. They're supposed to consider solar capabilities. Some subdivisions do that more than others. Solar is getting bigger and bigger, whether it's on top of people's houses or in vacant parcels. Certain solar developments you don't even have control over because it goes to the PURE and the Siting Council. So they kind of control things that get large. So in cluster developments, I know you have a planned residential development provision in your zoning regs. So there's certain tools that you can use to kind of change your typical cookie cutter subdivision. So, okay, you can, yes, great. Require the provision of open spaces, parks, and playgrounds. Any open space has to be shown on the subdivision plan. It should have some relation with the subdivision. Usually 10 to 15% is what regulations have. I think yours has 10% if I remember correctly. Again, this is something that you see with more often than not. with bigger subdivisions, which I'm not sure how many you're going to see. But the important part too is if it's going to be open space and it's going to be something that is owned by the town, you have to make sure that people like myself follow through for you. So to make sure that conveyance does go to the town. I've run into instances in other towns where there's been open space that was approved 20, 30 years ago. It never got conveyed to the town. So all there is a subdivision map. It says open space. And maybe sometimes the original owner still owns it because the town didn't follow through. So that's something to be aware of. It's a nitty and gritty thing. In lieu of open space dedication, there can be a 10% fee that can be paid, fee in lieu of open space. I don't know how often that happens in Old Saybrook, but it is a possibility under the statutes. And again, on the next page, require the provision of open spaces, parks, and playgrounds, which depends on the size of the subdivision. If it's a small one, you're probably not going to have a playground there, but you might have some open space. I mean, it might be some feature, whether it's wetlands or a stream or something like that, that could lead itself to open space. Now, there's certain, you'll see the quote here about subdivisions for families. This really doesn't come up that much because it's really hard to say, yeah, only my family is going to own these 5 lots forever. It usually doesn't work that way. They might own it for 1 generation. So I try to stay away from that provision. Waiver of certain requirements of the regulations. Whoops, did I skip a page? I apologize. No, I didn't. We're on 15, I'm sorry. I'm talking faster than the slides. I apologize.
I apologize too. Something's going on with my keyboard. I just want to go to the next slide.
Just so there's full disclosure, I asked Chris to do this clicking of these clicks because otherwise it would have never happened. That's all. I just want everybody to know that. I was like, Chris, please do this.
I'm not an expert clicker, obviously. But.
Well, you're better than I would be. I don't even want to imagine what I would do if I had this. Waiver of certain requirements of the regulations. If somebody this will happen, let's say somebody comes in, you have a provision that says you have to provide sidewalks. The developer or the applicant will say, geez, I'd like to have a waiver for that requirement. This sidewalk's going to go to nowhere. Nobody's going to use it, yada, yada, yada. It's up to you to make that determination. So you don't have to say, yes, we agree with your waiver. And it takes a 3/4 vote of all your members. So that'll come up in subdivision applications sometimes, depending on the circumstances. And sometimes you're going to get applicants that just want to kind of squeeze all your regulations away to a certain extent. And they'll ask you for like 5 waivers. And it'll be like, oh, what do you need all these waivers for? And so, be on alert for that because a waiver is a special thing in subdivisions. It's not something that should happen all the time. Okay. Now there's other things that sometimes happen in zoning regulations called waivers. We're not going to talk about that. They're no longer legal, but in subdivision regulations, they are. So, okay, we can go to the next one. Affordable housing exemptions. Usually I would think that, affordable housing has been done, I think, primarily in Old Saybrook on parcels that exist. You haven't had to do the subdivision part. So Old Saybrook has a history with subdivision, with affordable housing applications. They don't usually get tangled up in the Planning Commission. No, it's usually the Zoning Commission. All right. Next, what may also be in subdivision regulations are proposed highways, streets, or sidewalks, or things of that nature. These provisions really happened at a time when most towns hadn't been built as much. So they're sitting out there. Most towns, not all, aren't really planning for new roads. Sometimes they do. It's usually for industrial purposes or things like that, but it's not as a common occurrence at this point in time. Okay, changes in regulations. If there is a subdivision that's been approved and it's signed, it's on the land records, and you change your regulations, it doesn't mean that the people who have that subdivision have to come in and get a new subdivision approval. When they get it and they file it and it's on the land records, that's a property right. It exists. They have a lot. And if it's an old subdivision and it's a vacant lot, if they come in and they've never built anything on it, if they come in to get something built now, so let's say you have a 1975 subdivision approval, you would look to the regulations in effect at that time and sometimes you can find the regs, sometimes you can't. Again, it doesn't happen too much. Every once in a blue moon it does. And it's usually not something that you have to handle, but your staff will. Chris would have to figure that out, lucky her. And so that's really the regulation changes. Completion of required improvements. So in general, it's 5 years unless the applicant asks for an extension because they can't complete those improvements. Now, the statutes have many different modifications to this because of real estate busts. So sometimes there'll be a statute that says, oh, in 2007, you can have an 11 years or whatever the case may be. But in general, right now, if you approve a subdivision, let's say it has a new road, and there's 8 houses on it, they have to complete those improvements within 5 years. And if they don't, they should come in for an extension to get it up to 10. And so that's, every once in a super blue moon, you're going to find people that have trouble completing all those improvements. And if they're public improvements and there's been a bond posted for it, you start running into issues at that point in time. Hopefully you'll never have to deal with that. It's kind of a pain. Okay. Conditional versus final subdivision. So you can have a conditional approval that says, I'm not going to post security for the public improvements, the road. And so when I complete it and it's approved, or when I decide to post a bond, it can become a final subdivision. So again, that's kind of an applicant's choice how they want to go ahead doing it. Not most, but not all come in with a final. Sometimes you get people who come in for a conditional, they go and they build the roads lickety split, get them satisfied from the town engineer, and then they go to a final. Next is the bonding, or what they now call financial guarantees. You can accept surety bonds, but don't, because then all you end up doing is arguing with the insurance company. And they don't want to pay you money. I'm going to give you a little hint. They want to hold on to the eagle until they have to let it go. So you can do cash bonds. So that could be a passbook savings account. You could do even a letter of credit is better. Bonds are the least favorite, at least by me, that's for sure. And you'll get, the banks keep track of the letters of credit. And if you do have any passbooks, somebody has to, know who put the money in. And, sometimes these things disappear in a weird way. If someone comes before you to release or reduce a bond or financial guarantee, as it's now called in the statute, you have to either release or reduce the bond or provide a written explanation of any uncompleted work. And so normally what that means is your town engineer goes and says, hey, we can reduce this. It's $100,000 bond. We can reduce it to $45,000. You still got some curbs to put in. You still have some things you haven't quite finished. We don't want to release the whole bond. So that's that part of the coin.
We keep track of the bonds in the office and the accounting and the types of, typically we prefer cash bonds, but we do get letters of credit here and there, and we handle all the expirations. So when it comes up, will help, you know, the commission obviously explain what it is, what happened, but we really don't, I don't even know right now if we have any bonds for the planning commission. It's been so long since we've had a subdivision with a road or utility improvements.
You probably don't. It's not as common right now. Okay, maintenance bond is really a 1-year added guarantee to any public improvement. Sometimes, and usually, again, your engineer is going to recommend a maintenance bond, or they'll say, look, you know, we want to keep 20,000, make sure this road really settles right, or whatever the case may be. So those are things that when the time comes, you deal with your staff to say, look, give us a recommendation on this. And excuse me, that probably hasn't been happening as much. Okay, part 2, yay. Meetings, hearings, and decisions. I know this is exciting, so please bear with me in your excitement. Okay, processing applications. So I want to see all my participants. Man, I'm just fiddling with my screen for a second. Okay, when you get an application, it's received at the earlier of the next scheduled meeting or 35 days. If for some reason it's 9 times out of 10, it's your next meeting. So that's when the application is considered received. All right. And, you know, as a general rule, subdivisions, you want, if you're going to have a hearing, which you may or may not, depends. If it's a re-subdivision, you will. If it's a regular subdivision, it's up to you guys. You'd have to start that hearing within 65 days. You'd have to complete it within 35 days of opening it, and then decide it within 65 days of the close. And if it's just no public hearing, then it's 65 and then 35 days after the report of the Wetlands Commission, if it's applicable. And you can get 65 additional days with the consent of the applicant. And now with the executive orders, and I'm hoping these end someday because they're really wreaking havoc with my ability to think about land use applications. They already have additional time built in, but hopefully that won't be going on into the future forever, the automatic days that you can get.
And for the commission, those are the COVID executive orders, which
yes,
we haven't had to deal with, so they change pretty frequently and keep us on our toes.
Yes, that's very fair. And some of these orders may become legislation. There's a push for that. I don't know which ones, I don't know why, but personally, I know there's a push to keep the option of people to have kind of hybrid meetings. So for people who can't necessarily physically get to a location, I know that there's a push for that. I just hope it doesn't muck up the abilities for commissions to do their business. But some people love the Zoom meetings. I have trouble wrapping my head around them sometimes. All right, so we can go to the next one. Types of decisions. You can do an approval of whatever you see for your subdivision application. You can modify what you see. You can condition it. You can deny without prejudice, which basically means once you come back with something that's a little better, you can give a straight out denial. But any kind of denial, you know, you should give the reasons for. And if it's a subdivision application, you should say it doesn't meet A, B, C, D, or our engineer's report says that there's going to be flooding on this street because it hasn't been designed correctly, and things of that nature. Reconsideration, that's something that really comes up rarely. I put it on here because you could reconsider a vote if the legal notice hasn't been published. But now with our Governor Lamont's executive orders right now, they allow electronic posting on the website. So your legal decisions can get posted pretty quick. And it's kind of a brave new world there. It used to be you'd have to pay money. You still can do this. You can still pay money for the Hartford Current or whatever newspaper to publish your legal decisions and do your notices for public hearings. But the existing executive orders provide that you can also, you can put it on your town website. And I suspect that there's a big push for that so towns don't have to spend money on legal ads, because they can really add up. These newspapers are hurting for money, and one of the places they have increased their fees are legal ads, and the other one is obituaries. So there you go. Those are the two big areas that they're trying to make money. Sorry, it's sad. Automatic approval. All right, so this is important for the Planning Commission when it comes to subdivision applications. If you don't render your decision within the time frame, it will create an automatic approval. So the legislature, in its infinite wisdom, has decided that if you, the Planning Commission, don't act quick enough, then that subdivision, even if it's a bad one, I was going to use a different word, but I decided not to because I know we're getting recorded. So let's say it's a bad subdivision. So what that means is that it's going to be automatically approved if you don't act within the time frame. So don't anybody ever say that, oh, we don't have to act on that, we can wait. Figure out your time frames, make sure that you're acting within them for subdivision applications. The other type of application is with the zoning commission for site plan only applications. They can also be automatically approved. Special permits cannot be.
One thing that we do for zoning, planning, wetlands is we'll put an action item if you have a time frame, and it'll say open the public hearing by this date, close the public hearing, or put a note of an extension so that when you look at your agenda, you can see where you stand, and not try to say when was this received, when did we first hear this. So use that as a guide in the action item when we do get more formal applications.
Yeah, no, that's great that you have that. It's very helpful. It's actually super. COVID executive orders. These are like we've been talking about. Governor Lamont has issued many orders involving, COVID related safety features, I guess is really what it's all about. Trying not to spread COVID. What some of these things have to do with COVID, I'm not sure. I do know that, at a Zoom meeting, we're not going to pass COVID to each other. So that's probably a good thing. So your agenda should be online. If there's any relevant materials for an application or something that you're going to consider, that should also be available online for the public. The public can watch or hear meetings. And if it's a public meeting, you want them to have the ability to actually respond and provide public comment. Sometimes that's done easily, but it's not always the easiest thing. And we've had ones where, we have an appeal right now where there was an application, there was a public hearing, they were doing it, the chairman asked, well, does anybody else have a comment? 4 people raised their hands like this. For whatever reason, the chairman didn't see it. He closed the public hearing. And on appeal, that's one of the issues, is whether he should have closed the public hearing when people had questions. Now, that's easier said than done, because sometimes, like right now, the way I have my thing set up, I don't see everybody. So I don't know if anybody's waving their hands. But it creates additional legal issues. Like I said, the public notices for public hearings may be online. As long as the newspaper time frame. So you have to kind of follow the newspaper time frame and not do anything 10 days or less. Have it up there. Again, it saves money. You're not paying the Hartford Current. And you can hold hybrid meetings. There was a question at one point of whether you could. So what a hybrid meeting is let's say there's a bunch of you down at the town hall, 3 or 4 of you. You're having your meeting. You have a couple members that don't feel comfortable, even in a large room. So they still want to do it by Zoom or by telephone. And if it's a public hearing, you might have people that'll want to Zoom in. So hybrid is both physically being someplace and, Zooming. So it's a double. That may continue at people's option. I think it's a little confusing, but I understand sometimes, you know, for some people who may have trouble getting out, how that could be an issue. So we'll see if that ends up being part of our statutes. Okay, virtual meetings. This may be with us after COVID. We're going to have to wait and find out. When you're in a virtual meeting as a planning commissioner, as long as you're able to, and some people have technology issues, and I get it, you want to be visible and you want to act like it's a meeting at the town hall. So we all get used to sitting in our kitchens or our living room doing a Zoom meeting, and we start to let our guard down. We start to think like this is just like a, you know, a fun little thing we're doing tonight. And you want to just remember that, you know, like this meeting, it's being recorded. So if somebody wants to go on and watch it, then, you know, use the same decorum as you were if you were in the town hall. Be polite. Don't start drinking shots while you're doing this, okay? Keep those things in your own private world. Don't do them on a camera. Do not Zoom from your bed. That's a recommendation. I've seen it happen. It's very odd. And right now, we had an issue come up where during a public hearing, and it was a lengthy one of the commission members fell asleep. And it was obvious they fell asleep on the video. Now, we were able to rectify that, but just, you know, try to, and it's hard. Some of these hearings go on for a long time. Do the best you can to stay alert, stay engaged, and, you know, remember that if there's an applicant, you know, give them the courtesy of your full attention. Oh, social media, it's a trap. This is my attempt at humor. So I hope somebody's laughing out there. So that's some guy from Star Wars. I forget his name, but it's funny to me anyway. So if you're on social media, do not talk about planning commission issues that are coming up or applications, or stay away from, you know, and it's hard, you know, you get involved with something and all of a sudden somebody says something and you want to respond, you know, be very careful, be judicious. Don't talk about planning issues. Sometimes people post an agenda or to let people know. As a planning commissioner, you don't want to prejudge anything. You don't want to show any bias. Because believe me, somebody's going to do one of those screenshots. I would do them if I knew how. Would do a screenshot and they're going to have some weird thing you said about, you know, I don't like subdivisions ever. You know, so you don't want to lay that groundwork, because there are people that know how to do that. In fact, we did somebody in my office did the screenshot on that one where people had their hands up, and that's part of the return of record, to establish the fact that they didn't have everybody speak at the public hearing. Okay, statutory authorities on disqualification of matters before planning commissions and conflicts of interest. Okay, basically when it comes to conflict of interest, you're talking about personal conflicts or monetary ones, pecuniary ones. So they don't come up all the time, but you know, if you have somebody that comes before you and you know you're friends with them, good friends, you might want to say, look, I can't sit on this. All right. I know Mr. Jones very well. He's my best friend. I have to recuse myself. And it's hard because maybe your best friend thinks, hey, you know, I got Sally on the board and, you know, she's my best friend. She's going to have my back. You can't do that. All right. That's one of the reasons you want to disqualify yourself. If something comes up on that matter, you might want to say, you know, let the record note that I'm disqualified. I have a conflict, and you can either leave the room or whatever you think is appropriate. Leaving the room is usually the best. So it should be on the record, and, you know, you shouldn't take any part of it. So appearance 8-11. So don't go in front of other boards and commission on behalf of other people or even your own board. Obviously, if it's your own property, you have the ability to go before a board, but even then, be very careful. People really look at these things in a different light than you do at times. So don't represent anyone before another board or commission or your own board. So, okay, page 32. Here's other grounds for recusal. We went over conflict of interest. prejudgment and ex parte evidence. You know, if you're displaying a bias, if you're starting, you know, don't get involved in these things behind the scenes because it's only going to come back to bite you. All right. You have to be impartial. You have to accept these applications as they come in. And you don't want some email popping up where you tell an applicant or an opponent, you know, don't worry, I got this handled, it's going down. You know, you don't want those things coming up. So don't send emails to anybody regarding, you know, any member of the public regarding what you think about an application or anything of that nature. If you have specialized knowledge, if you have a degree, like you're an engineer or you're whatever your qualifications are, you might want to state that in the record during a public hearing so somebody's aware that, yes, you're asking these questions because indeed you're qualified. Always get yourself familiar with the record. If for some reason you missed a public hearing or a night, if you're a regular member, you should be able to listen to the tape, review the documents, and then you'll be caught up to speed. So remember to do that. Sometimes people can't make every night during a public hearing or discussion of an application. Yeah, the next I've kind of gone over, appearance and representation by commission members. Don't start representing people in front of boards and commissions if you're on one. I mean, it's just very simple. I kind of went over these. I'm doing good tonight. Financial interest, obviously.
You're ahead of me, Matt. What page are you on?
I'm 34.
Okay.
Well, I kind of, you know, sometimes I talk quicker than the slides, and I apologize. Financial interest includes a financial interest of a commissioner or members of your immediate family. If there's some way that you're going to benefit out of it, that's greater than to the benefit of the community at large. And I'll give you an example. Let's say, and it doesn't come up as much in planning commissions as it does in zoning. So like in a zoning instance is, let's say in your town, and I hope this isn't true, you only have one funeral home. And then there's another one that wants to come in, but they're not allowed in any other zone except one zone that this funeral home controls. So if you're related to the funeral home owner, you don't want to consider that because obviously your family is going to benefit from that. So if there's a particular business and you're the only one in town or, you know, things of that nature, then, you know, think about it. You know, is someone in your family going to benefit based upon this application either way? And if you have any self-doubts or if you have any doubts, you just recuse yourself. It is a lot easier to recuse yourself than to try to explain it away later. And if somebody raises something at a hearing and you don't think it's legitimate, you need to say that, well, you know, I don't think I'm biased on this. I have an open mind. And so therefore I'm not going to recuse myself. And it's important to do that too, because sometimes people come up with far-fetched things that, you know, oh, somebody lives a mile away and I think they're conflicted out of this. That's not the case. So it kind of goes both ways. And, you know, conflict of interest with close friends and other association with the applicant, you know, it can be a judgment call, you know, but, you know, be careful. You know, when you get that feeling that somebody you know has filed an application and you know them well and you go, oh, you know, geez, I know these people really well and maybe I'd like to do, then you know, I should recuse myself. That's an important thing to do. I mean, I was on a ZBA, so I know what it's like when somebody comes before you and says, you know them and they want a variance and you're like, oh, well, I know you too well. I have to recuse myself. So bias and predetermination. So everybody in the world has opinions, right? And beliefs. We can't change that. That's not something we can erase or say, oh, you know, you don't have any thoughts. However, if you go around saying things that might be considered a bias, either towards a person or towards a particular idea, and like I said before, like, geez, I really don't like subdivisions of more than 3 lots, you know, you don't want to do things like that. That shows that you're biased, and you definitely don't want, this is sometimes something that happens. There's a subdivision application filed. Somebody from the media gets a hold of your phone number. You haven't even had a meeting on it, and they'll call you up. This will happen someday. And they're going to say, what do you think about the Jones subdivision application? And you're going to say, I can't comment on that. It's really easy, because the media, their job is to sell things, even if it's bad things. They have to sell things. So keep that in mind. Don't talk about these things to people in the media, to people who may also, use it against you. Okay, avoiding the appearance of bias. I think this sometimes is hard. Because sometimes you want to ask questions during a public hearing that are pointed, that are deliberately stated in a way to make the applicant have to think or, respond intelligently. You don't want to create an atmosphere where the applicant or an opponent feels like you're against them. So if somebody says something and maybe you don't like it, you can say, okay, thank you. Or, if you're the chair, thank you. We'll take that under consideration. Be careful how your statements might be interpreted. There was an appeal where one of the commission members, I believe it was the chair, made a comment about the Italian-American applicant in something that everybody in the commission thought it was funny. The applicant thought it was funny, except when the judge read it in the transcript, he said, look, that sounds like, bias towards a particular individual. And so he remanded that back to the commission. So even though you might think it's not really a big deal, just think about what you're saying sometimes. Again, prejudice at a public hearing, that doesn't happen too much, but if you get a very controversial application, then you're going to have people that may show up and say things that you don't want them to say. And, when that happens, you have to say, look, we can't consider those things. And if they keep going, you're going to have to turn them out. You're going to have to basically say, look, you have to stop speaking. Your turn is over. And that's one of the hardest things to do, and that falls upon the chair. So the chairman is the person who controls the meeting, controls who speaks, who doesn't speak if it's a public hearing, and the whole flow of the meeting. And so it's a personal style, but if people start making racist comments, and I've seen it, you got to cut them off. It just cannot be tolerated. Again, predisposition, that kind of flows into my discussion regarding the media calling you up like, well, what do you think about, the Jones subdivision? Or are you going to approve it? Reporters don't really, they're just there to write an article. And, don't speak to them about substantive matters regarding the Planning Commission. There's nothing good can come of it. Keep an open mind. Don't publish things or send emails or go on Facebook and talk about applications. Even ones you haven't started a public hearing on, you just don't want to go there because someone's going to print something out and show up and say, see, you didn't like this application. I want you to recuse yourself. And it may be something innocuous. So, whenever somebody asks you, and if you have an open mind, you say that. Excuse me. Next page. In the event of a disqualification, that fact should be entered on the records of the commission or the board. So it should be reflected in the minutes, and you want to reflect it on the tape. Here I am, I'm recusing myself. I'm going to be out in the hallways. Please let me know when you're done considering this matter. And then if it hasn't been done already and there's an alternate there, they'll bring an alternate in to fill your space for that particular application. All right. Next page, the chairman is in control. So the chairman controls who speaks, when they speak, especially during public meetings, but even during regular meetings. The chairman's in control. They recognize people, then the people can speak. You want to have a meeting that is logical. You want to have one that follows rules. You don't want to have a bunch of people talking all at once because it doesn't benefit anyone. You can't make a transcript from it. It just comes out all muddled. It's the same with the public. Some public will want to go on and on and on. Sometimes you have to cut them off, or you have to say, if there's a lot of people there, that, you know, if you agree with someone who's spoken previously, please indicate so we don't need to hear the same argument over and over again. That's an important thing to keep your meetings coherent, and so you're not there till midnight. Clarity of motions and amendments. My understanding is, Chris, you've handed out some sample motion language.
Yes.
Yeah. And so, you know, I did take a look at that. That's a good idea to use. So you get in the hang of doing motions, writing motions up, and controlling your own meeting. What constitutes a meeting? Well, you know, I was talking to Chris about this today very briefly, but it's basically any quorum of a public agency, whether in person or by electronic equipment. That's like we're doing now. So what we did is we published the agenda, and so that's what we need to do because we're having a meeting. Let's say you were going to a training session. Like, for example, this March, there's going to be a training session for all commissions. It's going to be electronic. Let's say a quorum of you all want to go to this electronically. Is that a meeting of your commission? No, it's not. It has to be something that you're going to in control of, something that you're considering, and on things that you would act on, not educational matters. All right. What is not a meeting? It's a caucus of members of a single political party, staff meetings, communications regarding the notice of meetings or their agendas. I would even be careful with this. I would work through staff with this. I've recently run into an FOI complaint where somebody's saying, oh, they weren't really talking about the agendas. And so if you have a quorum, let's say you all decide to go for whatever reason to some other commission meeting, and there's a quorum of you, you're not there to conduct business. You just all happen to be there. That's not a meeting. When can the public be excluded? Well, there's provisions in the statutes that you can exclude them if it has to do with the selection of a lease, purchase or sale of real estate, when discussion would likely lead to an increase in price. As the Planning Commission, this will only come up usually during 8-24 approvals. That's not a time to go into executive session. If there is something that might be protected under Freedom of Information Act in your materials, which is pretty unlikely, then you could exclude the public. And you can also go into an executive session if you have a pending legal matter, which is the most likely thing. If somebody appealed one of your decisions and you wanted to talk to me about it, or, you know, consider a settlement or whatever the case may be, then you could go into executive session. And when you go into executive session, the people that can be there are commission members and people who are that you want there to be. So you might want me to be there as your attorney. You might want some other person to be there. And so your minutes have to reflect, number one, that you voted to go into executive session. Number two, it has to reflect all people that are in attendance at that executive session who are in the executive session. There's certain things about employment that you don't have to do. I don't know how often that'll come up for you to discuss employment matters. And that's when can the public be excluded? Personnel issues, that's employment or other things involving personnel. Pending claims and litigation, that's the most likely area that you might have is pending claims and litigation. So if there's an appeal, if there's some sort of litigation that you're involved, or maybe just involved a little bit, you might want to have an executive session for that purpose. For the purchase and sale of land as the Planning Commission, again, that would only come up at 8-24 approvals, and that would be out in the open. Public security issues, I don't think you're going to run into that unless things go really bad in Old Saybrook. I don't know what kind of public security things would be happening to the Planning Commission. Let's hope that doesn't happen. Okay, so public hearings and fact finding. You, the commission, are charged with evaluating the evidence that comes before you. And what's important about that is you don't want to hold your cards back. So let's say someone's doing a presentation before you and they say, well, Jones Hollow Road is a straight road. And you go to yourself, wait a minute, I know it's a crooked road. I go down that road all the time. You might want to say, well, Mr. Engineer, isn't it true that this is really a crooked road? I think it's crooked. You want to ask questions. So you want to give the applicant an opportunity to respond to your thoughts and beliefs. And that's an important thing. You don't want to be in a position where you have a public hearing or you have any kind of meeting where you're considering an application and then the applicant's done, and then you start talking about stuff that might sandbag them, that they would have had an opportunity to respond. Doesn't mean you have to agree with them, but you want to give people an opportunity to respond to your beliefs. Whether it's about your zoning regulations, I don't think this application, meets, tell me about criteria number 4. Is that really, do you really think that meets the regulations and why? So let people have that opportunity to address you in that sense of what your disbeliefs may be. I see that that happens a fair amount. You evaluate the credibility of witnesses. There may come a time that you have multiple witnesses, multiple experts about an application. You're the one that has to say, geez, in your own mind, I agree with Mr. Jones when it comes to deliberating. That is your foyer. You have that ability. You have to defer to expert testimony, but sometimes you can get conflicting. In fact, if you have more than one expert there, you're going to have conflicting testimony almost always. So then you have to consider that and see if that's really answering your question. And if you have like more than 2 attorneys there, you're probably going to get like 10 different answers. It's going to be crazy. You won't know who to believe. So if somebody comes, normally what happens if it's a public hearing is the applicant goes first. He presents the application. Kind of be wary of how much time they're going to use up. You don't want a situation in a complicated application where the applicant takes 2.5 hours and the public is like, getting sleepy, getting angry. Try to keep people on a short leash. Then the public will get to speak. If there's opponents, they get to speak. If somebody's there and they say, well, I want to cross-examine this person. Well, what you have to ask is, can you ask these questions through the chair? Most attorneys, most people say, yes, I'll ask these through the chair. If they say, no, I demand to cross-examine them directly, then you have to do so. It is something that is required under the law. That doesn't mean the witness, it's not a courtroom. The witness can give squirrely answers and we're not there to, say somebody's out of order. Site walks. When you have a site walk, you have to post it. You go on the site walk. You don't talk about the application itself. You can ask about, well, where's this barn you want to build, or whatever the case may be? Where's the stone wall you show on your map? I don't see it out here. And someone can show you where that is. but you can't discuss the application any other way. And I encourage you, if it's going to benefit you, to go on a site walk. Sometimes you see things you didn't know were there. You understand the property better. Evidence. So when people start submitting documents, you're going to have paper documents. Sometimes you get like electronic things. No matter what, you have to get a copy for the record. So sometimes people will do a PowerPoint demonstration. Well, if it's an application, you have to keep that for the record. You don't have to keep this one. That's up to you guys. Hi, Chris.
Hi. Just a question. I mean, we haven't had any public hearings with the Planning Commission, but in these Zoom meetings, what if someone is to start screen sharing and bringing in under the governor's orders new documents at the last minute? How should the commission handle that?
Well, they're supposed to be on your agenda, online prior to the meeting. I mean, that's what the executive order is now. But I'd be leery to just not have them come in. I mean, that would make me nervous. In the sense of an application, if they're responding to something, the problem is, who gets the last response. And that's,
so I guess what I'm saying is, if all of a sudden I'm at the meeting and I go like this, here's, this document, what does the commission do when they find themselves in that circumstance where they weren't able to get it up on the record, or the applicant wants to submit new evidence? I mean, do you have any experience with it? I know it's all new.
Well, most people have been playing nice as a general rule. Not everybody. But if there's something that they can actually submit, they can't just wave it up here, because the record is what you're waving. It's not the document. But if they can electronically submit it and they do so, I don't think you should not let it in. Because then someone's going to say, hey, this was a last minute thing, yada, yada, yada. That being said, you might get in the position where someone's going to say, the applicant, there's an opponent, he submits an 87-page report, and the applicant's going to say, look, we're getting sandbagged. We want to have the opportunity to respond to this. And then you're really talking about extensions and things like that. If you come on the last night of the public hearing, you may not want to let them submit it. You might say, look, you can submit it, but nobody can respond to this. I've seen that happen even before electronic stuff. So, it's tough to say no to a submission while a public hearing is open. It's just, you're asking for trouble, I guess.
Thanks.
Mr. Willis?
Yes.
Isn't for how long must the public hearing be posted in advance with the documentation? Is it 7 days before the meeting, or a couple of days? Or
there's a couple of parts.
Is there
to
a
that.
time frame?
Well, there is for the notice for the meeting.
You have to just to get a better sense of.
Yeah, usually commissions will say the Friday before, or the Tuesday meeting, or the day before, either 24 hours or more for someone to submit something so it can be distributed and put up on the town website. I don't know if you have a set rule that you use, Chris, or.
So right now what we're doing is all the applications, they go under, so if it's a planning commission application, if you go to our website, you go under planning commission where it says news and announcements. It'll have the application name, it'll have everything electronically, and we do our best. I mean, even to get things up the day of the meeting or as soon as we get. I mean, there's circumstances, and I think that's why I asked the question to Attorney Willis, where all of a sudden, it's 7 o'clock and somebody's like, here's my letter, and we can't post it that quickly, or those other documents. So we take care of, in the department, we take care of all your tracking and the uploading and making sure those deadlines are met and maintain deadlines that we had before COVID, packets go out a week in advance and so forth. So, I mean, the commission doesn't have to worry about the day-to-day operations, but it's good to know, what we do and that it's there, because sometimes a commission member or a member of the public will say, oh no, I never saw that on the website, or I didn't know where to find it. And it's all right there on our website. Does that help you, Paula?
Yes, that actually, sorry, I lost my video. I don't know what, it suddenly went out. I did get a message that I have an unstable internet, which I knew of, but I'm sorry for the interruption, but I certainly can hear you. I will try to find how to get on again.
There should be a little video camera by where the mute is. That.
Oh, now I've lost everybody but you.
Oh,
Chris. Oh, show grid video. Okay, all right. Well, all right. I'm here listening.
Okay.
So
we can hear you.
The host has asked you to start my video. Okay. Oh, okay. All right. Yeah, I'm sorry. Video problems, technical problems. It's a different color. Anyway, please continue.
Okay. So continue with public hearing procedures, ex parte evidence. If somebody gives you something not in the course of the public hearing, meets you in the grocery store and says, Paula, I want you to vote this way. Here's some things that you should have to do that. All right. You say, hey, hold on. I can't accept anything like that. And you may want to say during the hearing, Miss Jones came up to me and she, tried to give me something at the supermarket. I didn't accept it. The most common things is sometimes people start getting weird emails. You have to use your judgment. You can say, look, they sent me these emails and I didn't consider them, or you make them part of the record. So hopefully that won't happen. Post hearing correspondence. Sometimes people will send things into the town hall about a matter where the public hearing's already closed. Those aren't things that you should see. And so they should be sequestered. Receipt of staff input. So after the public hearing is closed, you can still hear from your staff and from your own experts, as long as no new facts are entered. So sometimes that gets a little complicated, but if they're just reviewing what was presented to them and at the public hearing, then they can comment on it. So you can get a report after the close of a public hearing from your own staff member. Okay. So voting, making sure you have a quorum when you vote. If you haven't been there for the whole hearing or the whole consideration of a matter, you're going to need probably an alternate that has been, unless you've already listened to the tapes and any materials that were provided. Hi, Chris.
And so one thing that we typically do, especially if it's a public hearing, which you haven't had many recently, is we ask that the clerk email you the audio so that you can catch up and you'll have it right after the meeting. But now you can also watch our hearings and videos and meetings on YouTube. So you can take advantage of that, and we try to keep it right at your fingertips.
Okay. Tie votes. If you move to approve something and there's a tie, that means it doesn't pass. So keep that in mind. Waivers, we went over that regarding subdivisions, requires a higher level of voting. And then we come to questions. Do you have any other questions? I should have put one question mark up, but I put 3 to make it more exciting.
Oh,
Can we get a copy of this?
Sure. I think Chris has it. She can
Yes.
distribute it.
Okay, that'd be great. Thank you.
Yep. Okay, well, if that's it, then thank you for allowing me to do this presentation,
well,
and hopefully it's been helpful.
well, Mr. Willis, thank you.
Oh, you're welcome.
Very informative.
Good, good. And if you ever have any questions, let Chris know and she can get a hold of me and we'll get to the bottom of it.
All right, thank you.
All right.
Thanks, Matt.
You're welcome. Take care.